I want to talk about one of the biggest misconceptions that I hear with regard to durable powers of attorney and healthcare surrogate designations in Florida. Real quickly, the power of attorney is who can make typically financial, contractual, dealing with the government, dealing with your banking, dealing with real estate, or who can make those decisions for you if you're unable to do for yourself. And the healthcare surrogate is, of course, who can make healthcare related decisions for you if you're unable to do for yourself. And the big misconception that I hear with both of these very common, very important Florida estate planning documents is that by signing them, you are losing your right to act for yourself, right? Some people think that if I sign a power of attorney, now I can't do my own banking. Now I can't sign my own contracts. Or if I sign a healthcare surrogate designation, now if there's a health crisis, the doctors are not going to talk to me. They're going to talk to the person I've designated as my healthcare surrogate. And that is not true. With both of these documents, as long as you are cognitively doing okay, right? As long as you can talk through and indicate that you understand what's going on and meaningfully communicate your wishes, any third party will always continue and prioritize you over whoever you've designated to be your decision maker. Now, the thing with the power of attorney is that you have to give your agent the ability to do for you and sign your name to important documents right away. Meaning with the power of attorney, you cannot delay its effectiveness. Once you sign it and you have this agent or attorney in fact, who is the person you've designated to be your decision maker under the power of attorney, they can do your banking and deal with your real estate and things like that. Now, if they abuse this power, there are civil and criminal penalties for doing that. So that being said, not that, we don't want that to happen, right? It's still a very important document. You want to make sure that you're only giving someone that you truly do trust this very important and powerful power, okay? But when you sign it, you don't lose the ability to do for yourself. The idea is typically there's a spectrum, right? As we get older, or God forbid something happens, we become infirm, sometimes even only temporarily. We need help doing certain things like paying bills or signing leases and things like that. And maybe we can still do other things. So sometimes you're allowing your power of attorney to do certain things for you, but not others. And then certainly when we have a durable power of attorney, if you become unable to do anything meaningfully for yourself, it's good to have this person that you've designated to act for you and help you essentially manage your life. Now, with a healthcare surrogate designation, same principle applies, right? As long as you can talk to the doctors and the nurses, they're always going to listen to you first. The person you have appointed, you now have a decision to make. With this document, you can choose to make it effective immediately, or you can choose to only have it effective if you've been deemed incapacitated. You don't have that right with the power of attorney. Powers of attorney, effective immediately. Healthcare surrogates, you can choose to make it effective at a later date when you become incapacitated. Often, if you're dealing with a trusted family member, I say make it effective now because it avoids you having to go get that incapacity determination when maybe important medical decisions need to be made rather quickly, right? So delays are not our friend necessarily. But if that makes you at all uncomfortable, I absolutely have no problem with making your healthcare surrogate, delay its effectiveness only upon you being deemed incapacitated. So I hope that clears it up. You do not lose rights while you have the ability to think and do for yourself. You're not giving anything up, but you are delegating, giving someone else the ability to assist you when you are partially incapacitated or fully incapacitated. And it can be very, very valuable, because what you don't want to happen, if you say, I'm going to forego signing this stuff because for whatever reason you can come up with, if you do lose your ability to make decisions, now your family is going through a much more expensive, time-consuming guardianship process, which can all be avoided if you have a good, durable power of attorney healthcare surrogate in place. Hope this clears it up. If you are anywhere in the state of Florida and would like to talk about estate planning, Medicaid planning, Probate Administration, these are what our firm does very well throughout the state. Feel free to schedule a consultation. If you like this video, please give it a thumbs up. Please share it. Please subscribe to the channel. We try to give out a lot of good, useful, practical information as much as possible. And thank you for watching.